Give me the action signal. Action. We're good. All right. Thank you, everybody, for joining. Thank you to the folks in person, and thank you to the folks online. We have a big audience online and a good stellar group here in DC. So very excited. Welcome to the ABA International Law Section Anti-Corruption Committee meeting on the DOJ's new Corporate Whistleblower Award Pilot Program. Before we get to the substance, I want to say a few thanks to different folks. First, thanks to the co-chairs of the committee, who are Josh Christensen at Paul Hastings, and Luis Miranda at Miranda Law, and Ernesto Alvarado at the DOJ. So a great group, and thanks to them for the support in making this happen. Also, Brian Howard at V&E for a vice chair who helps with all the marketings, which spread the word, so we have a big audience. And then we are going to have another event which has been moved from December to 2 weeks from today. So we'll have a discussion on conducting investigations and due diligence in China with a group, my colleague Feifei Ren from M&C here, as well as Tim Stanley from Risk Advisory, and Patience Bin, who's in-house. So very excited about that group, and that'll be in 2 weeks, and the official invitation will be out soon. And then for anyone who is interested, now is 'tis the season to join the committee in a leadership position. So if you're interested in a vice chair position or volunteering or getting more involved, we're getting organized for the next ABA year, which kind of breaks over the summer. So submit your information now. You can reach out to me if you have any questions or others. From M&C, thanks to International Department Chair Alejandra Almonte for supporting, using the space and everything for the event. And we have a big team that's helping to make this happen. Thanks to Michelle Brown, who I think is still downstairs helping people get into the building. And also Crystal, Rodney just left, and Gerardo for setting up the space. So thank you all to the team effort. And of course, special thanks to our special guest, Patrick, who was, I will say, was very excited from the first moment we started talking about this, which I greatly appreciate. So he's been an excellent person to work with and very enthused about this event. So thank you very much, Patrick.
Of course, yeah. Thank you for having me.
Patrick is, did you grow up in DC?
No, I grew up outside of Philadelphia.
Okay.
Yeah.
So
DC for 20 years. So.
No, not a Villanova fan.
No. Georgetown all the way.
And he came to the Walsh School of Foreign Service, which is an excellent school. And I'm making my final tuition payment this week for my daughter who's graduating there. And so he finished there and went across town to the Georgetown Law Center, and then started his career in the honors program at DOJ as a civil trial attorney in the tax division. And then also served as a deputy speechwriter for Attorney General Eric Holder. So that must have been fascinating. 2015, he left the DOJ and spent 4 years at the Consumer Financial Protection Bureau, which I just learned had offices directly next door. So he was a neighbor for some time. And then in 2019, moved back to the DOJ with MLARS, Money Laundering Asset Recovery Section, and is a trial attorney with the Bank Integrity Unit. And then in addition to the current role, he's also the department's whistleblower coordinator for FinCEN's whistleblower program, which we can get into today, which will be kind of an interesting add-on to the topics today. And then he was selected to lead the DOJ's new Corporate Whistleblower Awards Program, which is the topic for today. And that was launched in August 2024. So with that, I would like to turn it over to you, Patrick, and I will try to monitor questions online. Folks in the audience, feel free to raise your hand and kind of raise questions as we go. It'll be sort of fast and furious for the remaining 54 minutes that we have. We have a lot to get through, but feel free to ask questions as we go, as the topics arise. Speaking of fast and furious, I guess the place to start is the origin of the program, and I know there were announcements in I think it was March of
Yep.
2024,
Yeah.
and then a race to get the program implemented and launched. And why don't we start there?
Sure. Yeah. And thank you to the ABA and to you, Dan, for having me here. The views I express today are my own and don't necessarily reflect those of the department. So we began our whistleblower sprint back in March. The Deputy Attorney General, Lisa Monaco, tasked a group of prosecutors within the criminal division. So myself, a few other folks in NLARS, the money laundering section, the fraud section, to start studying the whistleblower landscape. As you probably know from your own practice, whistleblower programs have been wildly successful and really kind of a fabric of the American legal system. If you look back at like the False Claims Act from the 1860s. So, it came time for the department to say, hey, I think we want to get into this game and see how we can do that, how we can leverage our existing legislative authorities to create a program. So we spent, it's called the 90-day sprint, 90 days to essentially find out as much information as we could about existing whistleblower programs, about ways in which we could incentivize people to report on corporate crime, because that's really kind of the heart of this program, is targeting specific areas of corporate crime for folks to come forward. And we really just wanted to understand kind of, the state of play. So we talked to 50 stakeholders across the government, other federal whistleblowing agencies. As the newest whistleblower program, we didn't have to reinvent the wheel. So, we really relied a lot on our partners at the SEC, the CFTC, IRS, FinCEN, to really see what kind of program, what makes a successful program. And, we talked to a lot of folks in the compliance community, the defense bar, the whistleblower bar, to really kind of get as many perspectives and diverse ideas and thoughts about our program. So, it was a busy spring and summer, and then we finally, set up our recommendation to the Deputy Attorney General, and she implemented the program, and we launched on August 1st. And it's been, I say it was the sprint, but we're still really sprinting, and I think, the fun's really just beginning because it's still a new program. It's set to run for a period of 3 years, but there's, my hope and expectation that this will become a permanent part of the department. And I know that my team in place is really working, full steam ahead to make sure that happens.
Sounds good. We'll get into a lot of the developments about what you've been seeing and things like that. But before we get to that, what is the information that's most useful when you're kind of logging in and saying, all right, I got a new tip.
Sure.
What are you excited to see? What's the best information that you can get?
Yeah, and it's nothing. It's not rocket science. It's kind of the who, what, where, when, why of anything. When you're having clients come to you with any issues, or with government investigators and prosecutors, you really just kind of want to get a bearing of kind of who are the key players, where are the key documents, are they in the U.S., are they overseas? Really, with all of you toward kind of crafting our investigative plan as prosecutors, and we have FBI agents helping us, vet and triage the tips. Those are really kind of the main areas of, the whistleblower comes in, and it's obviously one person's account of what they may have seen or heard or witnessed. And it's really our job, I think, as prosecutors to do everything we can to corroborate, the information that they bring forward, to find out where else we should be looking, who else we should be talking to, maybe witnesses who we should refrain from talking to if we're still in a covert posture where we might have some investigative techniques that we want to do before we go overt with the company. And it's really just kind of using like your detective hat and just trying to follow the story that they're telling you, because the whistleblower has a narrative to tell you, and you're really just trying to fill out the details and get as much information as you can to see, to really pressure test what they're telling you to see whether or not it's something that, the department ultimately might want to pursue.
Sounds good. I think a lot of the folks certainly in the audience here have been following this closely, and probably a lot of the folks online too. But let's start with some of the specifics and the basics of the program, what's covered, who's eligible, how the awards are decided.
Sure.
What are the amounts, and of course, I mean, some of the interesting things are who's disqualified.
Yeah, no, definitely. So this is the kind of the nitty-gritty of the program, and a lot of this is found on our website, justice.gov/corporate whistleblower. And our program is largely modeled off of the other successful whistleblower programs that are out there. So generally speaking, to qualify for the program, the individual has to voluntarily provide the department with original, truthful, and complete information about corporate misconduct in one of 4 key areas. Those areas include violations by financial institutions, foreign corruption and bribery schemes, domestic corruption schemes, and then violations involving private healthcare insurance. And I know we'll probably unpack a little bit of that more in just a minute. Individuals who come forward also have to cooperate with the department, when they come forward, and cooperate with our requests for information from them. If whistleblowers' information leads to an award of a civil or criminal forfeiture in excess of $1 million, then eligible individuals can receive a discretionary award of up to 30% of the ultimate forfeiture that's ordered and paid, with a maximum award of $50 million. As it's laid out in the guidance, there's a number of factors that the department will consider in determining where in that 30% the individual might fall. So there's a variety of positive and negative factors, kind of depending on the significance of the information, whether the whistleblower first participated in internal reporting systems, which is something that we encourage people to do, and the program is structured that way. Whether the individual, delayed in reporting is something that we look upon as a negative factor. So these are all factors laid out in the guidance. Information under the program can come in 2 ways. Either it's independent knowledge. So here, think of like your former, current employees, people who have really just a firsthand account of what happened, but also people who provide independent analysis can qualify for the program. So these are experts who might have access to information and process it and assess it and analyze it in a way that adds to the department's investigative powers. Even if the department already has an open investigation into a particular entity, a whistleblower can still qualify if they come forward and give us information that materially adds to whatever we already know. So that's kind of the general outlines of the program. When it comes to who's eligible and who is not, one notable difference that I think is worth pointing out, and where our program differs from the SECs and the CFTCs and FinCENs, they have a bar against individuals who were convicted of the scheme for which they're reporting information on. The department went a step further. As prosecutors, we have other tools to encourage people to cooperate, whether it's cooperation plea agreements, non-prosecution agreements under the department's individual self-disclosure program. So under our program, individuals who played more than a minimal role, and minimal is the definition that we draw from the U.S. sentencing guidelines. Anyone who's more than a minimal participant will not be eligible for the program. So that's a real notable difference that I want people to know that's where our program differs in some material way from the other programs out there.
Yeah. And how we talked about how you're developing some more and improved tools for the system, but just take us through the mechanics of how people submit the information, how you receive it, how it's processed.
Sure. Yeah. So individuals, we have a website, and individuals can go online. There's an intake form. So folks generally fill out the intake form, submit it to a central inbox email address in the criminal division at the money laundering and asset recovery section, where I am in a team of prosecutors, agents, investigators, then analyze the information. And like I said earlier, what we're looking for is kind of the who, what, where, when, why of the corporate crime alleged. In the 4.5 to 5 months that we've been active, we've gotten over 300 submissions to the website, and I think we've been really pleased with the results so far. Just that the public has engaged so robustly with this new program in the short months that it's been live. When folks are submitting it, you asked earlier, like, what are we looking for? Just given the volume of information that we get, it's really helpful if someone has information to find to pitch the case. We only have so much, we have limited resources, even though it's really an all hands on deck effort right now to manage the program. But it's really important for folks, and the form really gives individuals an opportunity to really kind of summarize what it is. And then we look to see whether or not it meets that initial relevancy threshold. And I think maybe here it might be helpful just to kind of unpack a little bit of the 4 main areas, just because I think just to give you a sense of who within the department, what we're looking for. When we talk about foreign corruption, one major impetus behind the program is that we wanted to fill the gaps from the other whistleblower programs. Now, the SEC has a very successful program that covers issuers, but prior to this program, non-issuers were not covered. So that's where we're really targeting folks who have information involving non-issuers, private companies, foreign companies that may be engaged in some aspect of their scheme in the U.S., whether they're using U.S. bank accounts. Maybe there are some key meetings of the bribery scheme that are occurring within the U.S. that would get it within the criminal division's jurisdiction. Those are some of the things that we're hoping to incentivize people with information in those areas to come forward. We're also looking at violations of the Foreign Extortion Prevention Act. So that's really where, if you're looking at kind of the foreign corruption pie, I think the CWA really kind of completes the pie by filling the gaps that existed before the program.
And what's the DOJ authoritative pronunciation? FEPA? F-E-P-A?
FEPA, yeah. FEPA,
okay.
yeah.
All right. Settles the debate once
I know.
and for all.
It's a good question, yeah. In a financial institute, yeah.
Can I bother?
Yeah,
interrupt?
of course.
The question, because it's on the foreign corruption subject. I was curious to see that the focus is on, one of the focus is on FCPA and FEPA, but that foreign officials are excluded from being participants. So I was wondering if you could speak to that.
Yes.
And I'll just repeat it from Billy, which was the focus is on foreign corruption, but foreign officials themselves are disqualified from participating.
Yeah, and this was something that we had to think very carefully about every aspect of the program. So much of what we really wanted to do was set clear, transparent kind of guardrails and guidelines to the public as to what's covered and what's not. How to report information. And I think, when it comes to this question, and it's a great question. It's important to draw the lines around who is involved. We did that by saying anyone who's, not involved is eligible, but then people who are minimal participants can also be eligible. We also had to draw the line here. We have the restrictions in the program around U.S. government officials, and so we're also exempt from the program. And I think the idea behind that was that there are certain people within positions that should be reporting things by virtue of the role and responsibility that they have. No, but I take your question, and it's a fair one, but it is one that it mirrors the the restrictions that we have for U.S. officials, but it also tracks the other exclusions that exist in the SEC's program. But having said that, this is a pilot program. A lot of, what I'm doing is hearing and getting great questions and feedback from folks who maybe are thinking or considering other things that maybe we didn't have, the benefit of hearing from different perspectives. And yeah, it's one that that I personally haven't gotten in my time in talking about the program, but it's an interesting one and one that I think, I'll bring back to the team and kind of gauge what they think.
If it's useful, I mean, my thinking is that, well, certainly if someone in the Ministry of Petroleum, for example, has their hand out, that person probably wouldn't be eligible.
Right.
And that person would probably be pretty senior. But it is likely the case, especially in emerging markets, that someone below that person is aware that they've got their hand out.
Yep.
And it could be, and they could be actually be looking for an avenue to report on it because they don't like what's going on in their ministry, in their country.
Yeah.
Right. So it feels like it could be a fruitful avenue.
Definitely, yeah, and I think that's kind of the analog to just like your normal corporate context here, where the supervisor or director might be doing something and someone underneath them, a minimal participant, if they're not really involved to a great extent. I see the similarities there, and it's a great question.
Yeah, and you preempted one of our questions for if we had space, and I think the other interesting line you mentioned, like a Minister of Petroleum, but also all state-owned enterprises, if they're instrumentalities. So that would be a way. I mean, it could be an endless exercise to draw the line, but to have telecoms and other businesses that are generally operating like businesses. And James, you had a question as well.
Whistleblower comes forward and they realize they should have used one of the other programs, like it's about an issue and they should have gotten to the SEC. Do you tell them that, or do you just refer what they said to the agency? What's your role there?
Yeah, no, it's a great question. Our guidance, like I said, the program covers the 4 areas, but it's a pilot program. All of these awards are issued in the Attorney General's discretion. So, we often say, like, if you don't think, or if you're not sure where it falls, come to us, because then we can kind of do our tire kicking analysis and see, maybe this is something that we ultimately want to prosecute. For the person who comes and gets, maybe steps forward and doesn't get the right program, we encourage everyone to apply to multiple programs to avoid that instance. Of course, it's probably, inevitable that might happen. We're still developing guidelines around like how we communicate with the whistleblower and let them know. But I will say on the inside, we have really strong relationships with all the other whistleblower programs. We've started up these quarterly meetings just with all of the directors and senior staff where we can kind of exchange just tactical questions. And a lot of it gets to deconfliction too, and making sure that everything's kind of moving in the right direction. Mm-hmm.
Well, speaking of program confusion, I think at parallel or in tandem with these announcements, there were a lot of announcements from U.S. attorneys' offices and Main Justice about sort of the NPA program, non-prosecution offerings for people who come forward, which were often also referred to as whistleblower programs. And can you talk about the interplay between those programs and the corporate whistleblower award program?
Yeah, so the CWA, in my view, is really a whistleblower program because there is obviously a financial incentive and award for people who qualify. I think the other programs, I would call them really just self-disclosure programs because they're blowing the whistle on themselves, really. They're coming forward with the prospect, if they meet all the guidelines, that they will get a non-prosecution agreement, provided that they come in and give the government information, cooperate, and kind of meet all of the other requirements laid out in the policy. Both of these programs, so the criminal division unveiled its own in April, and our program, the individual VSD, voluntary self-disclosure program, and the CWA really kind of work in tandem, where if someone comes forward and it turns out that they have some exposure, then under our framework, they might be entitled to an NPA under the IVSD program, but they also might still qualify for an award as long as they are minimal participant in the program. So I think they really reinforce one another, and I think there was some I think both programs really further the department's work to hold individuals accountable and really boost our own corporate enforcement work. And yeah, so both programs, if someone comes forward under the CWA and it turns out that their participation is more than minimal, then we automatically will consider them for the IVSD program. So we see both programs kind of working in tandem and really getting toward the same end result of holding individuals accountable and then companies as well.
Okay. So speaking, I mean, that leads to another topic, which is a lot of the CWA language is about addressing the needs and the concerns of the whistleblowers themselves, confidentiality, anonymity, and anti-retaliation. And I know that's a big part of the program. So can you go through some of the key details there?
Sure. Yeah, so unlike Dodd-Frank or the AML Act, we don't have standalone statutory protections. But this was something that we heard again and again during our sprint, that it was important to have not just financial incentives, but also to have all these other protections for people, because whistleblowers at the end of the day really come forward at great personal risk, professional risk, financial risk. They're giving up a lot coming forward. So we very much acknowledge that. And in the program, when we talk about anti-retaliation, this is something that we take very seriously. Any threats that companies or individuals might take to intimidate, harass, threaten anyone who is trying to step forward is something that the department will take very seriously. This is laid out in our program guidance, and it's also addressed in the FAQs on the website for companies looking to kind of make sure that their own employees are staying on the right side of this program. If we find that there has been any kind of retaliatory action taken against whistleblowers, a company could lose cooperation credit. They could face increased financial penalties, sentencing enhancements. They could also face obstruction charges. So this is something where we want to make sure we're sending the message loud and clear to whistleblowers that this is something that we take seriously, and also to give companies fair notice that this is an area where even on the intake form itself, we want whistleblowers to be affirmatively providing us with that information to really understand not just the info they might have to report on, but also what happened as a result, and did they try to raise the concern internally, and what the response was. Confidentiality, like you said, is something else that's extremely important to whistleblowers. And, this is something that we will, to the fullest extent possible. I mean, obviously there are discovery obligations if we get to a trial in one of these matters where, the government has disclosure obligations. But, we go to great lengths to also protect the identities of the people who are stepping forward. And anonymity, individuals can proceed anonymously under our program if they have counsel. So that is one thing. If you do not have counsel, you have to obviously identify yourself so we can gather more information. So those are the three areas where, like I said, we heard these concerns loud and clear during this sprint. And I think, our program really mirrors a lot of those same protections that you find in the other whistleblower programs.
Under the SEC program, you can proceed with counsel from start to finish and remain anonymous. But under the DOJ program, even if you start with counsel, the whistleblowers may need to be prepared to step forward and sort of confirm their identity. And as you said, in some cases, even be prepared to testify. That's right. Yeah, and that also is in the SEC's program too, where the SEC essentially says, you can proceed anonymously with counsel up to a point where there might be other
obligations on the government to disclose. Say, for example, the SEC provides, the SEC gets a tip, and there's also it's an issuer, and there's a criminal case as well. We rely on the whistleblower information, and the whistleblower becomes a part of the case, then the whistleblower's identity would have to be revealed. I think also under the SEC program, identities have to be disclosed or at least verified in an acceptable format to the SEC prior to the issuance of the award. So
Okay.
we know who we're paying at the end of the day.
So it largely matches up. It's just the potential for discovery and trials if it goes to that, especially unlikely for corporations,
Yeah.
but for kind of spin-off enforcement actions against individuals.
That's right. Yeah.
Okay. And then speaking of anti-retaliation, there's related provisions in the corporate enforcement policy for anti-retaliation, which you've referred to. And then the emphasis over and over again of 120 days, which we hear, see a lot. Can we talk about your sense of, you talk to a lot of stakeholders who represented sort of the corporate compliance side. Can you talk about the elements that you have to address their concerns and how it works together with the corporate whistleblower award program overall?
Sure. Yeah. So I think just to step back so everyone kind of understands where we're at here. As I mentioned earlier, we incentivize people to report their concerns internally. If you do that, that's a factor that the department will look favorably upon when it's determining its recommendation for an award. So what that means is, say an individual step forwards, reports a concern to someone within the company. The whistleblower then has to report the same information to the department within 120 days in order to qualify for our program. On the flip side, there's also an incentive for companies to act quickly on the tips that individuals are raising internally. So we did that by amending the corporate enforcement policy. So what it means is if a company receives an internal report, they can still qualify for a declination if, number one, they report to the department within 120 days. And number two, they meet all of the other requirements, when it comes to remediation, cooperation, disgorgement, the requirements under the corporate enforcement policy. So, for companies facing an internal report, our advice really is to call us. If it turns out that, we find out from another source that a tip has been made, then the amendment is no longer available to a company. So really it's on the company to take those proactive steps to come forward. At the end of the day, the prosecutors may come knocking first, and that too will also knock the company out of the amendment. But I think really, we were, so much of the work that we do, all the cases that we resolve, if you check on the department's website, we lay out, a lot of what the company got right, what the company got wrong. And it really provides a roadmap to a lot of counsel and, advisors to really understand kind of how companies are getting it right. We really didn't want to take any measures that undermine the important work that companies are already investing in compliance, which is why we added that provision for individuals to report. And it was something that, we heard, from a lot of stakeholders, and they, had different perspectives and thoughts on it. At the end of the day, I think it's some stat like around 80% of whistleblowers first try to go internal. So it really, I think, is just, our program mirrors really the reality that a lot of whistleblowers are operating within their organizations. And I think it really just further sends the message that companies should be taking whistleblowers seriously, that they should be investing those resources to investigate the tips, to maintain lines of communication with the whistleblower, and then to report and remediate as needed.
And we'll get into kind of the current status, but maybe just to jump ahead to that point, I mean, without detailed numbers, of course, but are you seeing an uptick on corporate disclosures that seem to correspond to reporting?
So we're still analyzing and building out the data. I will say in all of our interactions and discussions with companies, it's clear that this is kind of on their radar, and companies, I think, are getting the message that they need to be proactive and forward-thinking when it comes to compliance. We have companies self-reporting all the time. I don't know, as I sit here today, how many of those are as a result of an internal whistleblower. But it definitely is a metric that we're monitoring, especially with this amendment, because really the hope is that the policy will encourage people to make that step, for companies to come forward to make the disclosure. And I think we might have some more information on that as we go on with the program.
Right. Okay. Well, maybe we just get into, and now it has been for almost 5 months. Maybe talk more about what you have learned so far and what you're seeing through the program.
So I think it's fair to say that we've been really pleased with how the public has engaged with the program. Like I said, we've gotten over 300 submissions. We've gotten submissions in all 4 of the program areas, touching on a number of industries around the world, from insiders, from former and current employees, from experts. So I think we're, all of the signals are going off. When we sent out, the policy, and we're really seeing kind of the feedback from the public, which is really kind of hitting on all the main points. There's always a ratio of signals to noise when you have a public program. Anyone can submit information, so that's not to say everything we're getting is actionable, is relevant, is something that the department ultimately will prosecute. And I think that's just the case, with any kind of public channel for people to submit information. But I think we've really, it's an all hands on deck effort. We have FBI agents who are specialized in each of these areas, who are helping us vet the tips. Prosecutors in the Bank Integrity Unit, myself and some other folks who were looking at the financial institution tips, fraud prosecutors, public integrity prosecutors. So we really, I think, our marching orders have been to make sure that this program succeeds, and I think we're really devoting all the resources to it. I think one other thing which I mentioned earlier was just like the collaboration with the other offices. I really think this is an opportunity, more broadly, not just with our whistleblower program, but really to kind of get on the same page and have all the regulators kind of moving in the same direction when you come to these programs, because deconfliction is a practical reality that you really have to skillfully navigate. And I think I'm really pleased by the way that we've kind of seamlessly entered. We've learned a lot from our other regulator friends who've already kind of had to grapple with a lot of the tough questions, but I think, going forward, we're all kind of, addressing some of these issues, head on together.
Yeah, maybe now is a good time to kind of take that turn and talk about the coordination you do across agencies, because that was really interesting to hear about.
Yeah. So so we have close, cooperation with our partners at all the agencies with the whistleblower programs. I will say, from where I sit at the Bank Integrity Unit, I also manage the tip and flow from the FinCEN program. And the FinCEN program, for folks who aren't familiar, I was talking about the foreign corruption kind of pie being completed. And, when we talk about financial institutions, FinCEN covers Bank Secrecy Act and sanctions violations generally. Also the Kingpin Act and Trading with the Enemy Act, but those are kind of the bread and butter of the cases. And in the Bank Integrity Unit, those are the cases that we criminally prosecute. Like where I sit, we brought Danske Bank, TD Bank, Binance. Those are kind of our core cases.
I've heard of those cases.
Yeah. We seem to have a big one every year. Yeah. So when it comes to our program, we're kind of completing the circle with financial institution violations. Whether it's money laundering, obstructing federal regulators, bank fraud schemes, bank bribery schemes. So when the tips come into us, they come into the Bank Integrity Unit, but also to our colleagues at the National Security Division. who are obviously looking at each tip with a view toward, whether there are potential sanctions violations, regardless of whether it's a financial institution. They're kind of looking broadly at it. So we'll work in close collaboration with our colleagues at NSD. And if it's a financial institution, we'll work those cases together generally. If it's a case that might involve a financial institution with an FCPA angle, we'll work in tandem with our colleagues at the FCPA unit. So, we really, because we have kind of a central clearinghouse, we're able to kind of keep tabs on who's doing what, because that's often a challenge, when there's a number of investigative agencies and different prosecutors and U.S. attorneys' offices, it can be a challenge. But I think we've really skillfully kind of managed the flow of the tips from the FinCEN program, but also our own program, because we get the tips, we know where they're going, we're keeping track on who has them, we have timelines, internal deadlines set for folks to work these tips quickly, because a lot of the information, some of it's, exigent, people are coming forward and saying like, this is happening, I need to talk to the government. So, when it comes to deconfliction, it's always kind of a work in progress, but I think because of the way that we've centralized everything within the money laundering section, we're able to kind of keep tabs on where things are being worked, who's working on them, how we're partnering with the U.S. Attorney's Office community, which also is handling these tips along with the main justice prosecutors.
And you're also coordinating with the SEC and other agencies outside of DOJ.
That's right.
As well.
Yeah. So yeah, no, we have regular touch points. There's a way that we can share information. Obviously, as criminal prosecutors, we have to be careful to keep the civil enforcement actions separate from the criminal prosecutions. So we're not all kind of deemed to be one team. But we navigate those those intricacies and are able to essentially through special requests at the agencies, if we know someone filed a tip with the SEC, they generally, on our intake form, we ask folks to let us know if you've done that, and then also to put the tracking number that you've gotten, so that we can then on the inside point the prosecutors to the enforcement attorneys, and then they can start having a discussion once they get the proper kind of safeguards in place to share the information.
Okay. What's the outlook for 2025? What's on the horizon here?
Yeah, so I think it's going to be another couple busy months and years ahead. I know there's been a large emphasis on corporate enforcement policies. We've had the compensation clawback pilot. We've had the individual voluntary self-disclosure pilot. Now we've had the CWA. And I think, with each of these, we're really trying to send a message to individuals, but also to companies with clear, transparent guidelines about what our expectations are. We're not there to tell companies what to do, but we're constantly communicating in our press releases, in our resolution paperwork. And I really encourage people, I'm sure everyone's already does this, but when we have resolutions, to really read through them and to see kind of how the department is weighing certain the company's cooperation, how they've remediated, kind of what their response was. So I think, you can expect more, we can expect a lot busier time. We're adding more folks to our team. So we're really kind of, I think, suited to, really poised to continue being a busy place. One other thing that I just want to plug for folks is the department's evaluation of corporate compliance programs, which is another publicly available document, which was amended in September. And the amendments, some deal with data, the use of artificial intelligence and new technologies, but also whistleblower programs. And this is an area where, while we don't tell companies what to do, the document is really a guide that we use as prosecutors when we're determining kind of where the company is falling in terms of its own remediation, cooperation, its own kind of proactive compliance work that we hope that they should be doing, or the questions they should be asking themselves. And at least with respect to whistleblowing, I think you can expect continued, scrutiny and examination of the companies, how they're dealing with whistleblowing. And the policy, the document lays out, we're going to be looking at the effectiveness of the reporting mechanism. Is it actually working in practice? The company's commitment to protecting whistleblowers and anti-retaliation provisions. We'll also be looking at how companies respond. How's the investigation response? Who's a part of investigating the tip? How is it, kind of from the life cycle of the tip? Is it moving along? Are the appropriate folks within the company doing what they need to do to stay on top of the issue and remediate? And the department will keep looking at the resources that companies are devoting to internal whistleblowing, and then examining whether the company is engaging in a properly scoped investigation. So these are all kind of areas where, again, I encourage people to take a look at this document. Again, it doesn't tell you you should do this or you should do that, but it really, I think, puts you in the frame of asking the kinds of questions that we ultimately will ask to get ahead of those issues and to really take kind of forward-leaning steps when it comes to compliance, so that, when you're sitting on the other side of the table from the department, the company can really position itself much better if they can say, we did X, Y, Z, and we did this proactively, and we were able to, to identify this, to remediate, and then ultimately to report it to us.
Okay. We're about 12 minutes left. If folks have questions, either online or in person, feel free to ask now, or I've got some as well. On that, we haven't really prepared on this one, but mentioning the ECCP, some folks seized on language that, as you said, it's all in the form of questions, so it's not like prescriptive.
Yeah.
But there are some questions suggesting that companies should affirmatively notify folks of the SEC and DOJ program, like whistleblower programs. What's your kind of reaction to that, or your thought on what's practical and doable or for companies?
Yeah, no, I know a lot of companies are already required, in the BSA context, to do a lot of training. So, from my perspective, it's we want these programs, we want companies to be taking these programs seriously. And I think one way they can do that is by educating, their employees about it. And, a lot of companies are already doing ABC training and AML training, BSA, all of that. And I think this is one way in which they can also, meet the obligations and the expectations really that are laid out in the ECCP.
Okay. Yeah, Billy.
Question, Dan, if you don't mind. I want to make sure I understand the corporate disclosure, the amendment, what you refer to as the amendment accurately. If a whistleblower comes forward to you, to DOJ, and also to the company, if the company also comes forward to DOJ within 120 days, they can still get a declination.
That's right.
But if the DOJ beats the company to the mark, do they lose the opportunity to get the declination?
Yeah.
Or
Yeah.
Okay.
Yeah.
So the company the company probably shouldn't feel comfortable that it's got 120 days.
Right. I mean, it's that's where we're, 120 days is not long. And it's really, if we find out from someone else in the company has not come forward, or that we've reached out first, then the amendment's off the table. Yeah.
Nicholas.
Staying on the same point about 120 days, that is not a long time. I'm comparing that deadline to, for example, the M&A safe harbor policy, which sets deadlines, but it also explains that which generally means so and so days. It's not as hard and fast as the amendments language. Was there any consideration about making or introducing a little bit of flexibility there? And I can speak, I don't know if, not from personal experience directly, but being Greek, just getting data from Europe and going through a European data protection agency, for example, can take more than 3 months.
Yeah.
Which means that the company has very little time to really assess whether or not they should come forward.
Right.
Wait, so I forgot to repeat the questions. With the first discussion was about 120 days and how the DOJ can still the 120 days should not be viewed as a guaranteed timeline for companies because the DOJ, whether it's national security or other issues, can still approach the company. And then the 120-day sort of guideline is out the window. And then Nicholas's question is, in comparison to the M&A safe harbor, which talks about 6 months or 180 days and a year, but those are general guidelines as opposed to 120 days solid timeline. Was there discussion of building in more flexibility for that to like a reasonableness standard or something like that?
Right, yeah, so I want to make sure it's clear, when you come forward to disclose, we're not expecting companies to kind of give us the full final report of what exactly happened, who's involved, and kind of the extent of their investigation. It really might be just putting a marker in the sand and letting the department know we identified an issue, we're looking at it. And once you reach out, through counsel to the department, we're going to expect periodic check-ins to really understand kind of what's going on. So it's not that, you have to have gotten to the root, the root cause of whatever the issue was and who's responsible. But we do expect companies to step forward and to make that disclosure, even if it's, we identified this issue and we're working on it, and we'll continue to report on it. And really, for companies, they should just, document what they're doing, continually, stay in touch with the prosecutors. And, I think that really will, from where I sit, send the message that the company is taking this seriously and they're devoting the necessary resources to get to the bottom of it.
And on the 120 days, I found it really interesting that people working in compliance or investigations or audit, if they share or if they know the information is shared with the CCO or the general counsel or the audit committee, and the company leadership haven't done anything within 120 days, then they go from ineligible to eligible for the award.
Yep.
Can you talk about that?
Of course, yeah. So this is a provision of our program that mirrors what's also found in, for example, the SEC's program. As I said, we really want to encourage companies to have those effective compliance, governance systems, reporting channels, and controls. And we don't want people in those positions in compliance and audit to run right to the government, because part of their function is, to funnel the information to get to the issue and to remediate. So you're right. Yeah, those employees, certain categories of employees like compliance officers, people in audit, directors are not eligible for the program unless one of these exceptions applies. So you are eligible if, number one, the whistleblower has a reasonable basis to believe that disclosure is necessary to prevent criminal conduct likely to harm national security, violence, or result in imminent financial or physical harm. And obviously the reason for that is we don't want people to sit on information that otherwise should be acted on immediately. Number two, these folks are eligible if they have a reasonable basis to believe that the entity or the individual is impeding the investigation. So is someone destroying evidence, as one example? Or, and this is the one that I think you referenced, at least 120 days elapsed since reporting to the relevant audit committee, the CLO, the CCO, or if these individuals obtained information under circumstances indicating that the entity's officers already knew of the information. So that's to say, if through the internal reporting that the relevant decision makers aren't doing anything with the information, then these folks in these special categories are able to come forward. We really want these employees in sensitive roles to be doing what they're expected to be doing and for the systems to be functioning as intended. And I think, the rule and the exception really provides some clear guidance to folks. I know the SEC has issued a couple of awards under these exceptions, under their program, under each of the exceptions. So, I think it really strikes the right balance of expecting folks to be doing what they should be doing in their positions, but then also having safety valves and different measures to kick in if the relevant folks within the organization are falling down on the job.
Okay. Two quick questions. One, end of year holidays, New Year's, does that result in an uptick because people are home at their laptops, or a downtick because they're enjoying their time?
Yeah, we've been busy, I think, every week. Yeah, we're always trying to read what's happening externally and see how kind of that affects the program. We are in the process of exploring getting an automated portal for our program, really just to kind of put us in the 21st century and modernize the system that we currently have, because the volume is increasing. And I think some of that we're hoping through data analytics to really understand a little bit more about the trends that we're seeing and how we can what we can divine from the information that we're getting.
And so you have new stats that I haven't heard about, more than 300 claims. Do you have the information? Will you share it eventually as the program builds, about per sort of pillar of the program, like we talked about the 4 different pieces?
Yeah. So I know the SEC, like some of the other regulators, have congressionally mandated reports where they provide that information. I definitely think that would be a helpful stat or figure to put out there. I'm not sure I'm the one to announce anything like that. It might be someone higher up in the criminal division, when we have kind of formal, reports or numbers to unveil. But no, it's something that we're tracking, because I think, this is a pilot program, as I mentioned, and a lot of really, not just getting the word out and getting great questions from folks like you. We're really also just trying to see where the hot spots are. We identified those 4 areas. The program is not limited to those, though. So, really our message is, if you have information to step forward, and, if there are any adjustments or modifications to the program, we'll be rolling those out on the website.
What about competitors submitting information? Obviously, corporations can't do it based on how you wrote the program, but a lot of times you hear disgruntled folks who are saying, I lost this contract because that company won, and they must be doing something wrong. And but maybe that's all they have.
Right. I mean, it might be like a speculative, like
Right.
they suspect that something's happening. But no, you're right. I mean, only individuals are eligible, so companies can't submit a tip. And if it all depends on kind of whether they fall into the original information, and they meet all the requirements. But something like that might be too conjectural for us to really act on. Yeah.
Okay. Unless there's any other questions here, we'll wrap it up. Thank you very much, Patrick. Really appreciate it.
Yeah.
Thanks, folks, for coming out. Thanks to folks online. And January 30th, investigations and due diligence in China. So our next event. All right. Thank you.